All right, I can see everyone starting to join now, so we'll get things underway. Welcome, everybody. My name is Mitchell Zaddo. I'm the Managing Principal here at Sharrock Pitman Legal, and thank you very much for joining us today for our webinar on issues we are seeing in property law recently. Before we get started, we would like to acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located. We pay our respects to their elders past, present and emerging, and acknowledge that sovereignty was never ceded. And we extend this respect to all First Nations communities throughout Victoria and wherever you may be logging in from. I know many of you have attended our webinars before, so welcome back. And if it's your first time, then a very especially warm welcome to you. And we hope these webinars are a helpful resource just for us to share with you some must-know information on guidance on different things that we are seeing in our practice and which we think might be of interest to you. You can catch up on these recordings from previous webinars on our website and heading to the resources page. We'll put up some more details about that again at the end. You'll find there the webinars that we've done from all areas of the practice, including commercial law, disputes, employment law, wills and estates, and of course, property law. And if you aren't so familiar with Sharrock Pitman Legal, we are accredited specialists accredited by the Law Institute of Victoria in several of these areas, including property law. So we're able to dive deeply into these issues and share some real expertise and experience with you. But today we're looking at some things we're seeing in the property law practice. And I'm joined by Andre Ong, Michelle O and Coco from our team here at Sharrock Pitman. Andre is a principal and an accredited specialist in property law, and Michelle and Coco are part of our property law team, and I know they're all looking forward to sharing their insights with everyone today. Before we begin, I'll just run through a couple of housekeeping items. We are recording the session, as I said, and it'll be available on the website soon, and we'll also push that out through our social media. So follow us on LinkedIn and Facebook if you don't already, if you want to know when it's available. If you have any questions throughout the session, please feel free to type away in the Q&A box in your screen. We'll try to get through questions as we go, and we do have some scenarios coming up, so we may hold some questions to the end of each scenario as well there. We will have some time for questions at the end too, but we are conscious of your time. So if we do get to the end of the hour, we may not be able to answer all your questions, but don't fret. We'll keep track of the questions and get back to anyone that we aren't able to get to during the session. And we'll also share our contact details again at the end, so you can feel free to get in touch with any of the team with any questions you might have about your own situation. But before we begin, we do have a disclaimer. We are lawyers after all, so forgive us for the fine print. Needless to say, we can only give some really general advice in this session. Some of the scenarios in particular, positions can vary depending on whether you're the purchaser or the vendor and so on. And of course, we're talking about property duties and transfers and those sorts of things which are covered by state-based legislation. So we're talking from the Victorian perspective. So just keep that in mind. Of course, get specialist advice on your own situation before doing anything. But hopefully we can give you some good pointers today. So I'll hand over now to Andre, who'll start taking us through today's content. Thank you, Andre.
Thank you very much, Mitch. As Mitch has said, my name's Andre Ong. I am an accredited property law specialist and the head of our property law team here at Sharrock Pitman Legal. So I just thought I'd give a brief overview of what we're going to go through today. A little bit different from one of our standard webinars. It's not so much going through a technical point and running through the ins and outs of that. It's actually running through a little bit of an update. The short stay levy has come into place now as one of the Victorian government's housing policies to help free up some housing, hopefully, from their perspective. Obviously, it might impact everyone out there who might own an Airbnb or any short stay accommodation. Definitions are quite wide, and Coco, you will run through all of the ins and outs of the short stay levy shortly. After that, and again, a little bit different from our standard webinar, we're going to run through a few different scenarios, issues that we've come into on the residential space, but also some of the lessons out of that can be carried forward into the commercial and industrial space. There are issues that arise between contract and settlement, things where we've had clients in the past or we've become aware of matters when we're acting for vendor or purchaser, where issues have arisen where people might be changing their minds. What can one side do or the other side do in those particular scenarios? What applicable bits of the Sale of Land Act or other legislation might impact that? And then closing off with development sites issues in terms of covenants and easements. How do those impact prospective development sites? What should you be thinking about if you're looking at a development site that might be impacted by a covenant or easement? So drilling down specifically into each of those scenarios. The first one we'll cover off, I call the impulse buyer situation. Where do you stand as a vendor or a purchaser? If there's suddenly a change of mind, someone's come through, they've bid, they've been successful, they've bought a property, signed a contract. Suddenly there's a bit of buyer's remorse. What next? So we'll go through that. Secondly, we'll run through a scenario in terms of the material fact disclosure obligations, whether you're buying or selling. What if you find out something after the fact that you think, well, hang on, I should have known that before I signed the contract? Where do you stand? And then finally, as I said, with covenants and easements, how do you deal with that in the real world? So running through these scenarios, we're going to have Michelle, who will effectively be representing the purchasers, and Coco, who will be representing the vendors. So you can see in each of those situations that there is a perspective from either side. And after that, we'll run through a bit of Q&A, but I'll try and deal with that through each scenario. So feel free to put in your questions as the scenario is going along and as you're hearing from both Coco and Michelle on each of those aspects, and I can try and wrap it up within a conclusion at the end of each one. So I will hand over to Coco to run through the short stay levy.
Thank you, Andre. Hi, everyone. My name is Coco, and I will be giving an introduction on this new short stay levy. So effective from 1 January 2025, this levy will apply to stays under 28 days, and it is calculated at 7.5 of the total booking fees. That would include GST and cleaning fees, but exclude any credit card fees. Now, if the bookings are made through the platforms, like Booking.com or Airbnb, then the platforms will pay the levy for you. However, if the bookings are made directly, then the owner or renter who takes the booking is liable to pay that levy and register in the portal. So a quick note is that the listing services that only redirect guests to another platform, they're not liable for this levy because they don't handle the bookings themselves. There are a few exclusions available. For example, if you're renting out your principal place of residence, that's your home, for short stays, the PPR exemptions could possibly apply. Whether you own or rent the property is not relevant. Having said that, though, the levy will apply to the secondary residences at your PPR land, like tiny homes, caravans, and granny flats. So the main consideration here is whether you enter and exit from the same door. Then the tricky part with these exclusions are to claim an exclusion, you actually require to submit a declaration to the booking platform in a prescribed form by the SRO, that's the Revenue Office. However, they still retains discretion here in determining whether your property falls within the scope or not. This means if the SRO later determines that your property falls within the scope where you've declared otherwise, then there might be interest and penalty tax applicable on top of the levy payable. Next slide, please, Mitch. Now, what if you're running like a hotel-like setup business? So we often get this question from independent short stay operators who operate maybe multiple properties and offering that to guests either via the platforms or they take booking themselves. So this is not a straightforward question because the answer would depend on whether the property qualify as a commercial residential premises exempt under the GST rules. So the classification actually referred to a 59-page GST ruling, which we've attached a link in the slides, that goes into great details about what characteristics will resemble a premises to a hotel and what doesn't. So some factors can include like the commercial intent, as in whether the property is operated on a commercial basis or in a business-like manner, or multiple occupancies, as in whether the property owner or the renter can offer multiple properties to unrelated guests at once in separate rooms. So one key consideration here to take into account is the commercial infrastructure of these properties. So you not only need to have a central management system, which accepts reservations, allocate rooms, receive payments and stuff. On top of that, you also need a commercial infrastructure to support the commercial operation of the premises. That would be a reception, a dining room and a bar, or meeting rooms, kitchens, laundry facilities, or car parks. So the difference of these type of business as compared to the hotels or the service department we normally see like Quest is that hotels are typically owned by single entity or a franchise model. So they're being professionally managed with standardized service provided. And then with those individual holiday apartments that are individually owned, like Quest, then they're generally managed collectively as well, and they operate under a unified brand. So some of the clients that we're advising could well be large-scale operators. They could own 50, 100 apartments or operate them. However, they would face the same problem of lack of commercial infrastructure here, or the property is not located in the same building. So from our recent discussion with the State Revenue Office, there is a sort of narrow interpretation of this exemption. It's leaning towards to be focusing on each individual property itself instead of the nature of the business you run. So we really need to look at each different property in detail before coming to a conclusion that whether the property falls in the scope or not. And if you do want a definitive answer, then you will need to obtain a private ruling from the SRO. So the warning sign here is that even if you tick all the boxes, as we've shown on the screen, there are common factors. The SRO still has a certain level of discretion on whether the exemption applies. And we can assist with any further inquiries on this or a private ruling submission. Now I will hand back to Andre for our scenario discussion.
Thank you very much, Coco. So we'll start off with, as I said, what I call the impulse buyer. So in terms of this situation, it's where does a vendor and purchaser stand if there's a bit of a change of mind after the contract is signed off? So we'll take as our example Fong and Kim, who are out cycling one bright Saturday morning. They go by and open for inspection. It's a little bit outside of their target suburb, but they look at the place, they start to taking liking to it. They have a chat with the agent, and the agent says, well, the auction's happening that day, so if they're interested, they better make up their mind quick. So, excited by what they'd seen, they put up a bid, maybe another few bids, and ultimately are successful. Contract was signed, deposit paid, they slap a sold sticker on the board, and then they cycle off after an eventful Saturday morning, and off they go. But as things tend to happen, a few days later, euphoria's worn off a bit, have a bit of a closer look on the online photos, and they start to get worried about a few things. They might visit the neighborhood again, maybe a few things not to their liking. There's a bunch of derelict shops. There's a bunch of derelict shops up the street, and suddenly they're wondering, hang on, is this actually the neighborhood that we were bargaining for? And then they look at the online photos, and all of a sudden it's not quite as rosy as when they saw it that bright Saturday morning. They're looking at it. There's some cracks in the walls. There's water staining in the ceiling. Then, and bad luck for them, a storm had run through the area about a week after the auction, and suddenly we've got a damaged roof as well. And driving past the place, the carport out the front, hadn't noticed it at the time. seems to be leaning heavily on one side. So they get very worried about all of this. And having seen all of that, Fong and Kim decide that what they need to do is get out of it all, get their deposit back, and rethink what their position should be. So they go see their friendly lawyer, Michelle, and Michelle gives them some advice on what they might be able to do about it.
Thanks, Andre. So in Victoria, auction sales for residential do not have a cooling off period, unlike private sale where the buyer has 3 clear business days cooling off period. Buying and selling property is already expensive when you get it right, but it's really expensive if you get it wrong. So for issue number 1 on derelict shops, unfortunately, the caveat emptor, let the buyer beware principle applies. Fong and Kim were responsible for researching the area before bidding. And for number 2, cracks in walls and water staining on the ceiling. For auction sale, the property is sold as is. It's up to the buyer to inspect the property before committing to the auction and final purchase. So the options for Fong and Kim are quite limited, but we'll advise them to get a building inspection to assess the cracks and water stains. If the inspection reveals material structural damage and it is found that the vendor or agent knowingly conceals such serious defects, they may have grounds to rescind the contract and get their deposit back. For the third issue, storm damage to the roof, and this depends on the extent of the damage and its impact on the property. If the roof was severely damaged, such as being ripped off and repairs would take a significant amount of time, potentially stretching beyond settlement date, they may be able to delay settlement until the necessary repairs are completed. However, if the damage is so severe that the house is no longer habitable, Fong and Kim could potentially seek termination of the contract. For the last one on leaning carport, if Fong and Kim notice that the carport at the front of the house is leaning to one side, this is a potential structural issue. It could indicate problems with the foundation, support beams, or overall structural integrity of the carport. They should have a professional to assess the situation to determine the cause of the leaning and the extent of the damage. I'm handing over to Coco for the vendor.
Thanks, Michelle. So from the vendor's perspective, we obviously want to hang on to the sale, and we don't want the purchaser to just get away with the buyer's remorse. So firstly, we would be saying, well, the contract is an unconditional auction contract. It was entered into on as is where is basis. So the purchasers would have had opportunities to do inspections before bidding. So any issues on the condition of the carport or cracks in the wall or the water standing or the surrounding neighborhood as to those shops are reasonably apparent during their inspection, or they can figure that out from reasonable due diligence. So they've chosen to bid at auction without obtaining a building inspection report, and it's their own decision. Now, turning into the storm damage, it's a more complicated question because it then becomes assessing the extent of the damage. So the vendor has a contractual and legal obligation to deliver the property to the purchaser at the same time as it was on the day of sale, except for fair wear and tear. So that is, it needs to be in the same condition as it was at the auction date, as at the settlement date. Now, the roof is obviously damaged, but it doesn't mean the purchaser can just get out of the contract on that basis. But rather, the vendor would have the opportunity to repair the damage before settlement. And if they can do that, then it means the purchaser doesn't have a right to terminate, because the statutory right to terminate only arise if the dwelling is so damaged and is unfit for occupation. So depending on the extent of the damage, as the vendor, we would be arguing, well, it's only part of the roof was damaged during the storm. Arguably, it doesn't make the entire property uninhabitable, and the vendors can fix the roof before settlement. To resolve the issue, we would then suggest the vendor to offer to repair the damage before settlement. And if the repair work can't really take place before settlement, maybe you've got a 30-day settlement period, then we may suggest withhold some money in trust pending post-settlement rectification. So say that's whatever amount is required to fix the roof. So arguably, as long as the damage is remediable, they're not required to, the vendors are not required to agree to the contract termination. Then about the structural defects, so if the purchaser's solicitor, Michelle, is trying to argue that any structural issues should have been disclosed, then we would need to ask them to prove that, number one, the defect is so severe that it constitutes a material fact itself. And number two, the vendor must have had knowledge of that defect themselves and deliberately failed to disclose it. So if they can't prove that, then it's hard to establish their right of termination. So I would just be making arguments about how the car park issue is not material, it's not going to affect their decision to buy. We have a legally binding contract here, and there's no clauses allowing them to just withdraw simply because they now don't like it anymore. Thanks, Andre.
Michelle, as you can see there's a lot of arguments back and forth for either side, and it's important to really dig down into each fact scenario. So I thought I'd throw an extra fact scenario in there, a little bit of a twist. What if the purchasers then find out that it was the vendors that had built the carport themselves a few years ago as owner builders? They hadn't said anything about this in the contract or vendor statements, completely silent on it. What happens in that situation? So Michelle.
Yep, thanks, Andre. So in this case, it would definitely be a breach on the vendor for failing to disclose owner-built works. And our client can request evidence of permits from the vendor, and it's a ground for them to, if the vendor failed to provide this information, because if the carport was built without a permit, it may be considered an approved structure. Up to you, Coco.
Thanks, Michelle. So as the vendor's representative, when we're instructed to prepare a sale contract, we always ask the client to confirm if there has been owner-builder works or if there's any building works at all in the last 7 years. So the purpose is to ensure that those works, if there's any, comply with the owner-builder disclosure rules. So if the car park was built or renovated by the vendor themselves as owner-builder in the last 6.5 years, then they must have included the permit, the owner-builder report, and if the work is over 16,000, then they also must have included domestic building insurance. So things could happen. In this scenario, we're definitely not instructed that there has been owner-builder work. Maybe the vendor has completely forgotten about those building works that have done. As the vendor, we can be in a very interesting position. Now, you can be as commercial as you can. We can propose that we failed to disclose this. We can get a report done now if it's still within time frames, or we can take up the responsibility to repair and fix the carport issue. Or alternatively, maybe we can considering offering them a minor cut on the price for the reason of the carport to make them happy and see if we can save the deal. Now, unfortunately, as I said, we can be as commercially as we can, but if proper disclosure on the owner-builder work was not made in the section 32, then we would be advising our vendor client that they do have a ground possibly to terminate the contract. So thanks, Andre. I'll pass back to you.
Thank you, Coco. I think this is a bit of a conclusion there, and it does very much in this sort of circumstance where you have a buyer who's showing a bit of buyer's remorse. It definitely pays to go through the detail of the property and the circumstances to try and find ways out if there are any. This owner-builder scenario itself is something we had a few years back. That particular purchaser was trying to get out of the contract for other reasons, not specifically about the carport, but as it had turned out, the carport was an owner-builder element of work. There was no proper disclosure on it. The lawyer on the other side was probably not aware at all that it had been owner-builder work, but the Sale of Land Act does give drop-dead rights if you failed to comply with the owner-builder legislation in terms of disclosure, insurance, inspection, as Coco has specified. So sometimes it pays to just dig that little bit deeper. You never know what you might find to get the client the outcome that they want from a purchaser's perspective. From a vendor's perspective, obviously we would fight tooth and nail in terms of the position, but if you do find a flaw like that, it's important to be transparent to the vendor so that they understand what their position actually is, and to be able to work through what the commercial options are, but understanding that there might be limits there, and there is ultimately an end point, and so decisions can be made with that understanding. So we'll move across to the second scenario. So this one is focused on the material fact disclosure rules. How transparent does a vendor really have to be? Vendor normally would have owned the property for a while. They've done things to it. What do they need to tell their lawyer? What should really a purchaser be aware of mandatorily under the Sale of Land Act? What should they be aware of when they buy? So we've got Ali and Jody. They buy a cottage as their holiday home. It's a nice wooden building located in a small town, beautiful view, nearby forest, all the things you'd want for a holiday home. Again, they're pretty eager. They sign up. They don't bother with they subject to pest and building inspection. Love the place, had a look, pretty happy. During the contract, before the settlement date, they decide, well, look, this thing's near a forest. We probably should do some termite barrier treatments for the house just in case. There's nothing really in the vendor statement or anything disclosed about a termite treatment, so they're just being careful. They thought they'd put that in place. So move across to the next slide. Now, it is a small town. Coincidentally, the pest controller that they meet with happens to mention that, a couple of years ago, the vendor had hired them to treat a really bad termite infestation that had gone through one side of the house. Now, obviously, on hearing that, Ali and Jody are pretty worried. They knew nothing about it. Now, at this point, they decide, okay, the best thing to do would be to get a pest and building inspection done because we don't know what the history is. We're now a little bit uncertain about what's been disclosed. The inspection finds the termites are gone, but there's really big evidence of damage that termites have left behind, including on some structural components of the house. Now, Ali and Jody, it's their holiday house, or they thought it would be their holiday house. They really love the place, but they're worried that, these issues that they found are going to really cost them in the long term. What can they do about it? So, Michelle, they come to you and they decide they need some advice.
Yep, thanks, Andre. So in the ideal world, a contract should be made conditional on a building and pest inspection to avoid a situation like this, especially if the cottage, in our case, is a wooden structure located in a small town and it's near forest, which may be prone to termite activity. In such cases, a pest inspection is crucial. Since past termite issues don't automatically constitute misrepresentation, we will advise our purchaser client, Ali and Jody, to gather evidence that the vendor knowingly conceals such defects. So we'll be sending a letter of demand to the vendor and their solicitor, setting out the following. So number one, we'll detail out the issue and we'll mention the specific parts of the property affected by termite. It could be the structural walls or foundation. And we'll highlight that vendor may have failed to disclose the presence of termite damage or past infestations, which could be a breach of the duty to disclose material facts. And of course, we'll request for a reasonable price reduction to cover the cost of the necessary repairs. Because termite infestation or damage is a material disclosure, and it can be proven that the vendor intentionally concealed it. This could be seen as fraud, and our purchaser client may have grounds to seek compensation. On to you, Coco.
Thanks, Michelle. So as the vendor's lawyer, I would then be saying the vendors are not liable for the compensation for the non-disclosure of the termite history in response to the letter of demand. Firstly, as can be seen from the fact, the previous termite infestation was professionally treated 2 years ago. There's no evidence suggesting that it has come back. There's no active termite to our client's knowledge. The vendor is unaware of any ongoing infestation. Now, since the issue was resolved 2 years ago, there was no disclosure obligation on our client's part. The purchasers themselves had the opportunity to conduct due diligence, including the chance to make the contract subject to a pest and building inspection, but they chose not to do that. So our client did not actively conceal any fact or mislead the purchasers. They simply had no knowledge. and they don't know about the extent of the damage that the previous resolved termite issue has caused to the structure. So also, if we've prepared the contract, there will be a building certificate number 2 from the council, which says there is a termite warning for the area. It's close to a forest. So if the termite damage was cosmetic and fixable, the vendor could also argue it doesn't affect the structural integrity of the house. But on the other hand, if the structural component is significantly affected, say the stones are so damaged and there's a safety risk that they will be falling down, then it may require further discussion as in the property that you are able to deliver. Thanks, Andre.
Now, the critical element here with material fact is that there is no black and white in terms of what is a material fact that needs to be disclosed from a vendor to a purchaser. There are guidelines in place from Consumer Affairs, and that is pretty much the only thing that people have to go on at the minute. There's been one significant case that has gone through. Ultimately, there's a lot of grey there, and it's about each lawyer advocating for their position, each side advocating for their position, and trying to show that from a subjective perspective, there was a critical element in that fact that if the purchaser had known about this, would have impacted their decision to buy. The other thing to be aware of with the material fact circumstances is that it doesn't give a purchaser necessarily an automatic right to get out of the contract. In this specific scenario, if the structural damage was so bad that maybe the house was going to fall down, and obviously there was expert evidence to that effect, you could be saying that the vendor could not deliver what was contracted for within the contract. There's some grounds to try and argue that. Obviously, there's going to be a fight on that kind of an issue. But if these things were just, as Coco has said, basically cosmetic in nature or not to that extent, then we're not really talking about a right to be able to terminate. We're talking about rights of compensation if there was a failure to disclose a material fact. So these things can be fought out significantly. Depending on the severity of the issue, though, it often does resolve with a commercial outcome in terms of some level of reduction in price, perhaps, or an offer to do an element of work before or after settlement, if that's relevant, to try and address the issue. The important thing to know, though, is that it is an area of grey, and I'm going to throw in a twist in there that will add to the grey. So, what if it turns out that the pest controller, yes, he had been there 2 years ago, but 2 years ago the property belonged to someone else, and that person was the one that had arranged the treatment, and the current vendors had bought it from that person, know nothing about it at all. So what's the circumstance there, Michelle?
Yep, thanks, Andre. So if it turns out that the pest controller had already completed treatment for the previous owner and the current vendor knew nothing about it, it will be a matter of whether the vendor had actual knowledge of the issue or if they were reasonably aware of it. So there's a clear distinction between the two. Actual knowledge means the vendor was fully aware of the termite issue, while reasonably aware means that the vendor, through normal diligence, should have noticed the problem. Now, if Ali and Jody notice a big hole in a corner of the property, it's hard to believe that the vendor or their agent wouldn't have noticed it as well. I mean, it's like when you walk into a room and trip over something obvious and then try to act like you didn't see it. So the vendor can't claim they didn't notice the hole. It's too noticeable to ignore. So unless the vendor is genuinely oblivious, or if the damage was hidden in a way that would have been hard for anyone to spot, it's reasonable to assume they should have been aware of the issue. Over to you, Coco.
Thanks, Michelle. So as the vendors, if they are genuinely unaware of the past termite infestation and the previous treatment, and that's our instructions, then we would just be saying they have a much better legal position, because the law only requires the vendor to disclose non-material facts. They're not expected to investigate any past issues that they will never be made aware of. So if the termite issue occurred before the vendor's ownership, then they had no actual knowledge of it, or is under no obligation to carry out a pest inspection before they try to sell the house. Turning on to Michelle's example of what if there's a hole on the wall that indicates a reasonable person there would notice there's termite issues, then we would just be saying, well, it's a holiday house. We might be there for 4 weeks in a year. We might just not notice that. It's really depending on whether you have the actual knowledge or not. So here the purchasers have made a decision not to make the contract subject to a pest and building inspection. Had they conducted the proper inspection before signing, they would just become aware of any past termite activity. It's the responsibility of them to conduct due diligence. And they cannot now use this as a reason to terminate the contract or seek compensation. So if I'm representing the vendor and they're genuinely not aware of the termite history, then we would say the purchaser's attempt to demanding compensation probably lacking some basis. But again, it's up to the extent of reasonableness. So I'll hand it back to Andre for our next twist.
You remember? So the guys have said there's some level there where, again, you can argue that grey and what should have been so what the vendor should have been aware of, depending on the actual facts. So yet another twist. What if during the sales campaign, Ali and Jody had been making it clear to the vendor's agent that they were going to buy the property with a view to demolishing the little cottage straight away and building their dream holiday home? So it's a development sort of scenario. Now they might be thinking, hey, it's going to cost us some money with this termite. What should we do? So Coco.
Yeah, so I'll start with this one because now the situation even got better. Now, Ali and Jody's, their stated intention, as if it can be proven, was to demolish the cottage and build a new holiday home. Then the termite history is less relevant to them, and it's more unlikely that it's going to be a material fact for them because, as Andre has said, material fact is a subjective test. So it's a fact that would likely affect a reasonable buyer's decision to purchase or the price they're willing to pay, but it's only to Ali and Jody, it's not to a reasonable person. So if Ali and Jody had always intended to demolish, even if the termite history was disclosed, it would not change their decision to purchase the property itself. So it will be hard to establish a causal link between the non-disclosure of the termite history and their decision to buy the property because they will be demolishing it anyway. So this indicates that the purchaser could be looking for a price reduction, but we could probably have some grounds to turn that down. I will pass it on to Michelle for any arguments that purchasers may raise.
Yep. Thanks, Coco. So I would advise my client that even they have made it clear to the vendor agent that they were planning to demolish the cottage and build their dream holiday home, it was just an indication of their intention for the property's future use. However, even though their long-term plan is to demolish and rebuild, it does not exempt the vendor of their material disclosure obligations. The vendor is still required to disclose any known issues with the property, such as termite damage, regardless of the buyer's intended use. From a developer's perspective, it's common to rent out properties temporarily, perhaps via Airbnb, before proceeding with demolition or construction. But this does not change the vendor's duty to disclose material defects, as those issues could still affect the property's condition and value, regardless of whether it is rented out or left empty before demolition. It could still provide grounds for seeking compensation or negotiating a price reduction to account for any necessary repairs or damage. Back to you, Andre.
Thank you very much, guys. So just to reiterate there, it is very much a subjective test in terms of what a prospective purchaser, a reasonable prospective purchaser might want to use the property for. So if you're acting for a vendor and you're working through a situation where there's a prospective material fact that you've become aware of that the vendor is telling you, well, in that sort of situation, you've got to be having a mind to what kind of person might be buying this property, does that cross over into that material fact disclosure requirement? Or again, is it still within that grey? Is there room to maneuver from vendor's perspective, knowing that if a purchaser discovers the fact later on, it may well be relevant to them, or they'll certainly argue from a purchaser's perspective that it's relevant to them to try and perhaps get a price reduction. There is one case that has gone through the courts all the way through in terms of the Supreme Court for this sort of issue, and in that one it was related to a suicide that had occurred on a prospective development site. And in that case, the purchaser was obviously trying to get some compensation for that historical fact, but ultimately the court had found that it was not material to them in wanting to buy a particular site as a development site. So that subjective test is crucial. I guess as a purchaser, it might pay to keep your cards a little bit closer to your chest and not be so transparent in terms of your future intent, so as not to give the vendor any ammunition. So we might move forward to the next scenario. So in this one, departing a little bit from our vendors and purchasers and that sort of discussion, we're moving more towards a prospective development site now. So we've got a Jen and Alexis who are looking for their first residential development. Exciting times for them, of course. Ideally, they're looking for something that'll fit, a 6 to 8 double-story townhouse units, somewhere in the middle or outer ring of Melbourne. They find their ideal property, large block, old house on it, few trees, pretty flat, easy to build on. A little further out than they'd hope, but it's the price of housing nowadays. So they send us the contract vendor statement for review. We discover an old covenant registered on title. Now, the covenant has some words in it referring to a single dwelling, buildings being brick, stone, and masonry, buildings only being single story. What does all that mean for them, Michelle?
Thanks, Andre. So while the covenants prevent a hurdle, but it's not an obstacle that cannot be overcome. We will advise Jean and Alexis to have the covenant removed or varied. So engaging with counsel early and reviewing past cases in the area would definitely support their case. If surrounding properties have successfully had similar covenants removed, this strengthens their argument. But if the council refuses to remove the covenants or if objections arise, they can apply to Supreme Court for an order to remove or vary the covenant. But of course, before they make an offer to purchase, Jean and Alexis should weigh in the following factors. Firstly, they should assess the legal and financial feasibility of pursuing a covenant removal application, including costs, timeframes, and the likelihood of success. And for cost-wise, they may want to consider offering a lower purchase price to account for the potential risk associated with the covenant. And of course, they must be prepared for the possibility that the covenant may not be removed or varied, which would prevent them from proceeding with the planned townhouse development. So this approach will ensure that they are fully informed and prepared for the next steps. To you. Next slide, please. Andre?
Yep. Thank you very much, Michelle. Just to conclude a bit with the covenant side of things, it is important for purchasers looking at that to be aware that although there are grounds to get a covenant removed, it is not an automatic right, and there may well be reasons for the covenant to remain. So it is a function of both the purchaser understanding that they will have to invest some money into it, but also the time. So it's going to start to delay what their prospective timelines are. Holding property obviously has a cost, so they've got to factor that in. But at the same time, when they put an offer up, they may well be more competitive than others, having that broader understanding. And they're putting themselves in the right spot, but obviously discounting things, factoring in the additional investment they've got to make. So in addition to those covenants, they also see some lines across the planner subdivision that's in the vendor statement. A few dotted lines across the back. Not really entirely sure what that means. There's words like drainage easement, carriageway easement. What does that mean to them, Coco?
Thanks, Andre. So there are some lines across the plan for the properties. So that indicates both drainage easement and carriageway easement. So both type of easement would limit the development of the site. A drainage easement is a legal right given to water authority, council, or your neighboring properties to allow for the flow and management of the stormwater or wastewater. And then these easements often have strict construction restrictions. So typically, buildings cannot be constructed over a drainage easement without consent from the responsible authority. So therefore, Jing and Alexis will need a build over easement permit from the local council and water authority. We would advise client to contact them, as in the council and the water authority, to confirm the exact restrictions imposed by the easement and make an assessment of whether build over easement permit is a feasible option. So then they also need to consider the additional cost, and as Andre has mentioned, the timing and also the engineering requirement involved in this type of application. So if the easement is so severe that it restricts the development and it lacks ground to be removed, then they may need to consider revise their townhouse design or consider a different site. Then similarly, there's the carriageway easement, which is a legal right of way that allows another party or person to pass over the land. So this is more common where areas with shared driveways or laneways, the carriageway need to stay clear at all times, and they can't put fencing, walls, or any permanent structures over the easement. So if they can't vary their design to avoid this easement, then they might need to consider if there are grounds for changes to be made. For example, to vary the easement or realigning the easement, or like a complete removal of the easement. So there are some grounds that to remove the easement. For example, there's the abandonment, which require all parties, as in the owners, the mortgagees, the lessees, and the tenants, to confirm abandonment by entering into a deed. Or it can be extinguished where both the beneficial land and this land, we call it dominant and servient land, owned by the same entity, as in you can benefit from yourself. So it's extinguished. Or it can be removed in an adverse possession application sometimes. But most importantly, one thing to note is that any removal of the carriageway easement would then need council permission. So I'll hand it back to Andre.
Thank you very much, Coco. So just to clarify there, you can remove an easement by agreement between the parties, and then the abandonment can also be a separately approved application. But the abandonment does need a lot of proof. We have run those applications in the past, especially in relation to carriageways, trying to prove a negative in terms of people not accessing a particular pathway can be quite difficult, and you need to have pretty solid evidence as to why that access is long abandoned or no longer necessary, and having to prove it to council to get that required consent, and then having to prove it to Land Victoria effectively requires you to make that argument twice to separate government authorities that don't pay that much attention to what the other one says. So adds to that complexity for Jin and Alexis in this sort of scenario. If they're buying it with these easements in place on the expectation that they will remove those, again, it's a factor of them making sure that they've addressed the costs and the risks of that, what happens in terms of backup plan if the easements don't get removed, and just allowing adequate time for those processes to run through, which carriageway easement in particular may well be a matter of years. So it's not necessarily quick from their perspective, but something to factor in buying. So moving forward a little bit, they do decide to buy it. So then there's a bit of another twist in the tale. So they buy it, they're happy enough with those other risks, but after they bought it, and they start looking around the land, getting surveys done, doing a little bit more investigation. They suddenly find that there's a pipe that isn't marked on the plan, isn't noted anywhere else, but it crosses one corner of the land, separate outside of the easements. It crosses one corner of the land and it goes across into a neighbouring property. And they find out that that is actually the water supply pipe that gets the water across to that neighbouring property. It's the easiest way to get across there. They try and have a chat with the neighbor, but the neighbor doesn't really want to have a bar of them at all. What do they do about it? What's going on here? Coco.
Thanks, Andre. So now Jane and Alexis have now discovered that the water pipe crosses the corner of the land, cut across it, and then to supply water to their neighbor. So given it's not noted on the plan, assuming there is no registered easement for this pipe, so the issue is then whether the neighbor may still have a legal right based on the long-term use. That is an implied easement under Section 12 of the Subdivision Act. So the legislation provides that an easement can be implied by necessity or convenience, particularly when it is essential for the reasonable use or enjoyment of a property. So if the pipe has been there 20 years without any dispute, the neighbor may claim a right to keep it in place. This means the pipe limits what can be built in that corner. And then in terms of their options moving forward, first would be start to open a discussion with the neighbor again and asking them if they will agree to relocate the pipe, maybe offering to pay for the costs so it doesn't hurt the neighbor. Alternatively, they could considering offering an alternative route for the pipe so that has less impact on their proposed development. For example, instead of a line straight pipe that cut across the corner, can turn into an L-shaped pipe, maybe do a little twist so it doesn't affect their development as much. It can just sit in the corner. Then they could also consider engaging as lawyers to investigate whether those water pipe is legally compliant. Because if it's not, then some council and water authorities may be statutorily required to have it removed for compliance purpose. Then if all of these doesn't work, then they will need to consider council intervention or even apply for a court order. So I'll pass on to Andre for conclusions.
Thank you very much, Coco. So as you can see there, when you're looking at a development site, there can be a few twists and turns, and ultimately that does reflect in the price of a property you would expect. So something that's plain vanilla, nice, flat, rectangular block to put some townhouses on will attract a particular price. If you suddenly have these covenant issues, easement issues, you have a few different roadblocks that people need to consider when buying, and ultimately that will factor its way into the price. And I have had discussions with developer clients in the past where they're looking for these from their perspective, more marginal sites perhaps, or riskier sites, but that give them a bit more upside. Using that knowledge, a little bit of which we've shared with you today, using the knowledge that they've got with covenants and easements and rights to be able to remove or vary them as a pathway to acquire something maybe for a little bit less, run through that process, factor in the time to do so and the cost for doing so, but run through the process to get those variations or removals in place, which will then for themselves create that nice little block that they can then subdivide and make their profit off in the end. So a few different twists and turns there where some knowledge and a nice early discussion with your lawyer can make a big difference in terms of the future feasibility of any project. So hopefully those scenarios were very useful for everyone. A nice run through of all sorts of different twists and turns in sales and purchases. So I'll hand back to you, Mitch.
Thanks very much, Andre and Michelle and Coco. We do have time for one or two questions. If you would have something that you would like to ask, feel free to pop that in the Q&A box, and we've got time to cover one or two of those. In the meantime, while I give you a moment to do that, just a reminder about our resources page on our website, where this webinar will be uploaded shortly, and you'll be able to find other webinars across the firm. Here are some examples of some recent property law related ones to do with there's been a lot going on, particularly in relation to duties and taxes in the property world recently. So the team have covered things like the commercial and industrial property tax, leasing tips and traps, all those sorts of things. So if there's anything that you're coming across in the property space, check out that page on our website for webinars and also articles that the team are regularly publishing as well. We haven't got any questions coming through, so I'll move on and just start to wrap things up. We do have our next webinar coming up next month on the 18th of March, which will have an employment law flavour to it. So pencil in the date. We'll share some more details of that over coming weeks. And we do have another property law one coming up in a few months' time in July. So if you'd like to pencil that in, you can save the date. Just a quick plug, if you'll forgive me, if you are running a business or a not-for-profit enterprise and you're interested in how a systems-based approach could assist in sort of guiding you towards achieving success in your enterprise, can I commend to you David Sharrock's book, Fighting for Enterprise Success Through the Eye of the Tiger. If you haven't seen it before, it's full of lots of self-assessment tools, templates, samples, stories and learnings from David through his business journey. It's a very high quality publication. I can definitely recommend that to you. It's available in hard copy and also in ebook formats. So if that's of interest, feel free to get in touch or go to the fightingforenterprisesuccess.com website. And that brings us to the end. Here are the contact details again for the team. So if there's something that's come up today that's sparked something for you, feel free to pick up the phone or send an email. The team's always happy to have a chat or be a sounding board for things. And in the meantime, we'll leave things there and we'll see you next time for our next webinar, and have a great day. Thank you.